Hello everyone, welcome to Chai and Chat with Mohini. I'm Mohini Singh. Today we have an incredibly important issue to discuss. It's about the tension, the relationship between tenants and landlords. There was a time in the Kelowna area when the tenancy rate was under 3% and finding a place to rent was almost impossible. Now it's under 7%. And that tension, that relationship between a tenant and a landlord can be very adversarial. And when that happens, it can be very, very difficult for both parties. To help us navigate our way through this whole discussion, we have Chai and Chat's legal team here, Tyler Maneet and Maneet Sidhu, who are with Benson Law in Kelowna. Thank you, gentlemen, for being here. Before we get into our chat, how about some chai?
Of course.
Oh, love to have some chai.
We love the coffee cups with
You mean my mug on the mug?
with Mohini's mug on the mug.
I don't see your sunglasses on the mug though, but that's a very articulate thumbs up.
You know what? I was told that my podcasts are very formal, so I'm taking it down and making it very, very informal and just a chat.
Thank you for having us.
Thank you for being here. Now, to begin with, as I said in the opening, the relationship between a landlord and a tenant can be good, but on the other hand, it can also be a very adversarial relationship. And when that happens, both sides lose. I wonder if you could speak to that from a landlord's perspective. Let's start with the landlords.
Yeah, so some of the tips and tricks for a landlord in particularly, it's not so much tips or tricks from a legal standpoint, but it's just common sense. What I've normally seen from a landlord's perspective is not doing their own due diligence.
And what is that?
So due diligence is essentially you have a prospective tenant that wants to rent your property. And in doing so, what you should do is a significant amount of background check. So what I mean by that is making sure that you contact their references, make sure that you understand their employment income, whether they have stable employment, whether their references check out, any sort of that background information so that you as a landlord have an educated decision to make, knowing that you have a tenant that's going to be someone that's going to stay there for a period of time and can pay the rent respectively.
But even then, that's not foolproof.
No, not at all. So I typically, when I advise clients when I was practicing in the residential tenancy issues, normally you have to do, this ties in with your due diligence, but specifically what you should do is your checklist as a landlord. So effectively you want your move-in checklist. So you and the tenant are going through, and this checklist is readily available at the residential tenancy website. So you essentially mark down what the condition of the property is, and you and your prospective tenant are going through there marking down what the condition of what particular items like the dishwasher and like are.
But Tyler, this is not legal stuff. This is common sense.
Yeah, common sense, but you'd be shocked that a majority of the issues that happen from a legal perspective are because there's no due diligence on common sense.
And a lot of this does come out to legal stuff as well. Doing your checklist at the beginning is a really important part of actually making sure that you comply with the Residential Tenancy Act. So a big part of it is making sure that you do your move-in inspection, because without your move-in inspection, you can't claim against any damage deposits, being damage deposits or pet deposits. So making sure that you have that checklist in place before actually entering into that tenancy is really important, as well as making sure that the tenant signs, the landlord signs, and everyone actually attends. You also have to give your tenant a reasonable amount of time and opportunity to actually attend one of these inspections before moving in. And the same applies for when they move out. You have to do a move out inspection and give reasonable amount of time as well as opportunity in order to allow the tenant to attend these inspections. So that's where we do see a lot of pitfalls in law.
This makes perfect sense in a perfect world. You might have nuisance tenants, and then what happens?
Realistically, you should be documenting everything either via text or via email. That way, if you ever need to go to the residential tenancy branch, you're able to provide this as evidence saying, okay, I gave 3 attempts pursuant to the Residential Tenancy Act in order to allow them to attend for this inspection, but they failed to attend, so therefore I'm claiming against the damage deposit.
Oh.
So.
And what happens, there have been cases, Maneet, where the tenant, knowing that they have to move out, deducts their damage deposit off the next month's rent, off the rent, what recourse do you have then?
Well, realistically, the tenant is allowed to do that as long as it's mutually agreed upon. But the thing is, regardless of you holding a damage deposit or not, you're still going to have to apply to the RTB if the tenant doesn't consent to you withholding their damage deposit or pet deposit. So you'd have to apply to the RTB and try to seek remedies through the RTB.
Okay, here's the other thing. The RTB gives you a notice saying, yeah, you win, you get the money. What do you do then? Your tenant doesn't pay. What do you do then? Yeah, you got the notice. So what?
That's the other issue. So then you basically have to locate them. If you can't locate them, you basically apply to small claims court, depending on the amount. Sometimes it could be in the Supreme Court of British Columbia, and then you apply to small claims court. And then if you can't locate them, you still have their phone number, possibly their email address, so you can get an order for substituted service where you actually serve them via email, via text, any other method that you have available to you based on this order for substituted service. And once you get that, you serve them the documents, and then you actually summon them to a payment hearing. If they don't attend the payment hearing, you can actually have a warrant for their arrest issued if they don't attend.
If I can interject too, I think one of the pitfalls is for landlords, if this ties back into the due diligence aspect, is usually when tenants leave the property, it's almost next to impossible to track them down.
Yeah, it is. It's absolutely
And
is.
so sometimes based off of my practice, when I was practicing residential tenancy issues in the past, it was almost next to impossible for the landlords to have any sort of viable recourse in order to claim any monies due, left, and owing to them. So a prototypical example is a landlord comes to the property, the tenant's already moved out, whether they contest the return of the damage deposit or not, and the whole entire house is left destroyed or in shambles and beyond repair. What's your recourse? Well, generally speaking, these tenants have no fixed address, and if they don't provide a forwarding address, it's almost next to impossible to track them down.
Then what?
What's going to happen is that a landlord is either going to go through their insurance, try to go the legal route respectively to get some sort of recourse on damages on their property, and other times the landlords are left with holding the bag and fixing their property themselves.
And leaves the landlord hooped. Now let's speak from the tenant's perspective. Since now we're talking about the landlord's perspective. From the tenant's perspective, you have a landlord who is not fair, is not dealing properly with you. As a tenant, you're living in this house and things break down, the landlord doesn't fix it, so on and so forth, is after you. What are your rights?
Yeah, I mean, there's a plethora of rights there. So depending on what the emergency is. So the landlord is responsible for the upkeep of the residence that you're staying in. For example, if the washer breaks down and starts leaking water, right? There's emergency provisions of the Residential Tenancy Act that allow for emergency recourse to the RTB if the landlord is not being responsive enough in order to fix this particular item, such as the dishwasher and the water leak. That's particularly one aspect that you see from time to time. The other one is like pest control. I've seen the odd time here and there where rodents overinfest a property. That ties into a potential breach by the landlord to not keeping the residents into a particular state where, for example, it's a health issue,
Yes.
right? So
IJ could come down. The health authority could be drawn into this too. This is a very serious matter, rodent infestation. So what then?
So normally in the recourse there, that the tenant will either make an application to the residential tenancy branch to force the landlord to comply with the Residential Tenancy Act on an emergency basis, and to fix particular items, such as the dishwasher example would be one of them, so that the tenant can reside on that particular property. There is instances where specifically, say if you have a fixed term tenancy and all of a sudden the washer or dryer breaks down, they're 6 months into the tenancy and the landlord's not being responsive. I've seen it where tenants have applied to the residential tenancy branch in order to essentially break the lease or the fixed term lease to leave the property due to emergency issues. Yeah.
And like I said, nuisance tenant, but what about a nuisance landlord? What do you do then?
Yeah,
So at the same time, there is other recourse with the residential tenancy branch. I've seen plenty of cases where landlords promise they'll provide certain things within the lease, such as parking stalls, things like that, and where the landlord does not comply with the actual residential tenancy lease itself. You can apply to the RTB as a tenant and get compensation for services not being provided under the Residential Tenancy Act. This includes minor things as well, such as snow removal. Realistically, landlords, for the most part, are responsible for snow removal and things like that as well. So where tenants have to go in, clean the snow, winter after winter, they can actually apply to the Residential Tenancy Board and get compensation for having to clean the snow and things like that. If they are promised 2 parking stalls, but they only get 1 parking stall, that's technically somewhat of a breach of a lease. It's not a material breach where the lease could be terminated. It's possible that it may be terminated, but there is typically compensation available, and it's quite substantial for the most part as well when you calculate monthly rent and then the reductions for not being able to use a service, whether that be parking stalls, snow removal, not being able to use a dishwasher, if there's portions of the house that are unusable due to water damage or anything like that. So there's recourse for tenants in that aspect as well.
All this sounds like house cleaning and boring issues, but then when you're stuck, it's really important to know and have this information.
Yeah.
And I was going to say, I know only too well. I had a situation which attracted police attention on a rental property that I co-owned, not once but twice, and then several other times. Further down from me, another house, same thing happened there. So as landlords, we have to protect our assets. As tenants, you have to make sure the landlord lives up to the terms of agreement. So there's that tension in that relationship. One's the asset protector and the other is wants to live the best he can or she can. So rapid fire questions.
Go crazy.
What's the takeaway from this discussion? What would you like people to know?
What I would like people to know is to actually go through the Residential Tenancy Act. That's where you get basically a guideline of what your responsibilities are as a landlord, what your tenant is responsible for, and the other way around as well. So it's going through it, it's a little bit of a longer document, but of course, knowing your rights and obligations under a tenancy are worthwhile to look at because that's what we as lawyers rely on. And we have clients come in all the time. They've breached their lease and the Residential Tenancy Act, and then we're stuck with the mess afterwards, and sometimes we can't fix it. Lawyers aren't magicians where we can make problems go away when you've created those problems for yourself.
Damn, you're not.
Yeah.
Well, sometimes we are. Sometimes it goes our way. But what I can say is it's literally a lot of legal issues stem from people just failing to do just common sense and due diligence. If you do that in advance before your tenant moves in, I'm speaking on behalf of a landlord's perspective, you'll be shocked that you'll have less issues. So doing the due diligence, doing the checklist, the move-in, move-out checklist, as Maneet also referred to, is something that will actually have a very harmonious relationship with your landlord and your tenant as well. So not doing that, there's perils and there's pitfalls, and some of those pitfalls will be you'll have problematic tenants, and it's very difficult to get them out because, respectfully, the Residential Tenancy Act and the Residential Tenancy Branch, the scale weighs, in my respectful opinion, more towards tenants than they do landlords.
I know. I've been there. I've worn the T-shirt. Yes.
Yep.
Well, you don't have the mug for it, though.
I don't. Thank you, gentlemen, for being here. It's been great talking to you.
Likewise.
And this is very important information for people to know. And thank you all for watching this edition of Chai and Chat with Mohini. If you want to get a hold of these fine gentlemen, you could catch them at Benson Law in Kelowna. If you have any suggestions that you'd like to see on the show, please email me. My personal email is mohinisingh@shaw.ca, which is mohinisingh@shaw.ca. We have a very special guest here tonight. The future lawyer will be sitting in one of these seats. Everly Fulkert is here. Come on up. She wanted to
I
say
love-
hello and goodbye. Say goodbye and thank you for watching.
Bye. Thank you for watching.
Thank you all from
job.
all of us here at Chai and Chat. Goodbye.
Bye.